type of email communications. And certainly people who are passive-aggressive in nature will often say and do things in the form of an email that they would never, ever do in a face-to-face conversation. And that includes everything from being critical to being provocative or soliciting certain types of behavior. And it is amazing to me that they don't realize how permanent these communications can be. Obviously, you can shred a piece of paper, you can burn a piece of paper. They think, I guess, because you can delete an email that it disappears, but I think, as we probably hopefully all know, it doesn't actually disappear. It doesn't actually go away. It is going to be saved on a hard disk. It can be saved in a temporary file in a user's RAM. And, of course, whoever it gets distributed to, it's going to be on their laptops or maybe their handheld devices. And oftentimes the same is true for text messages, instant messages. People use Facebook now, and they'll communicate that way. All these things can be subject to the e-discovery process, and of course it makes the entire discovery process that much more complex and really at the end of the day more expensive for the employer. As we talk about what an employer can do in this particular arena, and we're going to focus on sexual harassment, although this goes to almost any claim that an employee can bring to the employer, I think we need to start here with just giving a quick overview of sexual harassment, and then we'll talk about, in the process of talking about sexual harassment, we'll talk about how an employer can minimize their exposure to a sexual harassment claim, and we'll touch on time and again how electronic communications need to be addressed in those efforts to minimize the employer's exposure to liability. Sexual harassment is defined as an unwanted act or behavior with sexual overtones which relates to the workplace or employment. You know, there's a couple of key phrases in there that you need to pay attention to. Unwanted is probably the one that is most litigated. Any unwanted act, or what does unwanted mean? You know, well, it's going to really depend on the specific facts of each case. But the question is, did the victim solicit that conduct? Did the victim invite that conduct or encourage it or participate in that conduct? And if she did participate, why? I say she just because that is typically the case, but it's not always the case. But if she did participate in the conduct, is it because she was enjoying it, she wanted to, she invited it, or is she simply participating in it so that she doesn't make a scene, so that as soon as it's over she can quickly retreat and escape that particular situation? Those are all fact-specific questions that the case is going to turn upon. And then you have to decide, okay, let's say it was in fact unwanted. Was it truly undesirable? Was it truly offensive, not only to her subjectively, but also in the objective sense? Was it offensive to the objective reasonable person? Was it objective to the, or offensive rather, to the objective reasonable woman? Those are questions that courts are going to wrestle with when they decide whether or not conduct was in fact unwanted. And then, of course, you get to issues regarding whether or not it leads to a detrimental job impact on the victim, or whether it creates such a hostile work environment that the terms and condition of the victim's workplace have actually been altered. And again, you're going to have to get into the specifics of each case. The Supreme Court has given us some guidance, at least to employers, on how they might, at the outset, best protect themselves against potential liability. And I think we can go to the next slide. There's really about 3 or 4 points that the Supreme Court has made in case law over the last 10 or 12 years that has provided employers guidance. First, what we know now is that sexual harassment can be both heterosexual and homosexual. It does need to be sexual in nature. It needs to have the sexual overtone, but it's no longer necessarily limited to heterosexual behavior. It can, in fact, be homosexual. There is some question out there as to whether or not it can be bisexual. Generally, sexual harassment is rooted in the notion that we don't want one gender to be disadvantaged over the other and therefore subject to harassment where the other is not. There's an argument out there that if it's bisexual, then both genders are being subjected to the same type of harassment, and therefore it's not discriminatory. We'll see how courts wrestle with that in the years to come. But we do know now that it is not limited to heterosexual behavior. It can also be homosexual. Now, when you get into harassment itself, there are different scenarios where it occurs. If you have a situation where it is a superior harassing a subordinate, and as a result, the subordinate suffers some sort of adverse or detrimental job impact, and you can be talking about being fired, demoted, transferred, pay reduction, disciplined, whatever the case may be, if they can point to some sort of adverse job action that was taken against them, the victim, then they have a claim against the employer. And in that scenario, where an actual adverse job action has taken place, the employer really doesn't have any affirmative defenses. It can't really argue that, well, hey, we, the employer, did everything that might reasonably be expected of us. We're really sorry this happened. Now, there are other scenarios where there is no adverse job action that actually occurred. You just have a general instance of sexual or sexually charged misconduct, a hostile work environment. And in that situation where there is no adverse job action that took place, the Supreme Court has said, well, even if it's a superior to a subordinate or coworkers, the employer does have a defense where the employer can say, look, we did everything you might reasonably expect us to do. And so what does that mean? Well, the Supreme Court has given us guidance there as well. They said, look, an employer can avoid liability, but it has to establish that it has a policy in place that helps prevent harassment. It has to establish that it has educated its employees on this policy, that it has encouraged the reporting of harassment when it does occur. And then when reported, the employer does, in fact, take prompt remedial action. It does investigate the claim, and it does take some sort of final action to help prevent that type of harassment from occurring again. If the employer can do all of those things, then the employer has taken the necessary steps to establish an affirmative defense. An affirmative means that the burden is on the employer to prove this in court, but it's taken the necessary steps to protect itself from liability in a sexual harassment lawsuit. So what are those steps? Well, you look at a slide that says minimize harassment liability due to email. We're going to talk about it in general, but also we're going to talk about minimizing liability in general, but we'll talk about it also as it specifically relates to electronic communications. First, you want to limit the authority to make these job impacting decisions to just a select few people, and you want the employees to know that. In other words, you don't have to worry about that first scenario where the subordinate takes an adverse job action against the employee for some sexually related reason if that supervisor doesn't actually have the authority to make that decision. And so, depending on your operation, but to the extent possible, you really want to limit the decision-making for hiring and firing, promoting, demoting, transferring employees, pay increases, pay reductions, discipline. You really want to limit that authority to a select few people and make sure that those decisions are all carefully reviewed, hopefully by more than one person. And in doing that, you go a long ways toward limiting a scenario where